The state of Illinois is supposed to respond to Attorney Thomas Magg's Fifth Amendment challenge to Illinois' gun and magazine ban today. That's according to Judge Stephen McGlynn, who denied the state's motion to delay a response on the Fifth Amendment challenge. This, as you've also got a court hearing set for early next month in that ongoing litigation. Welcome back, Bishop on Air. Like, subscribe, hit that notification bell if you support what I'm doing each and every morning from my home office. Please do check out some of the merchandise as well, or just simply, like, subscribe, hit that notification bell, and share this with your friends. All right, let's get into it because there's a lot of angles to the latest in, gun control and litigation against regulations, including this week's U.S. Supreme Court hearing in the Chevron case, which is kind of fascinating, especially in the conversation in the context of Illinois. While the Chevron thing's more of a federal rules issue, I think it's something that can provide more context and understanding to a state like Illinois that has administrative rules and agencies essentially interpreting the law through a rule-making process, and how those rules really could be changed when the political sea changes or when the political headwinds change. So we'll touch on some of that as well, but also the Uvalde school shooting report from the U.S. Department of Justice, pretty damning in as far as the police response to that mass shooting. But let's get into the latest out of the Southern District of Illinois federal courts, where we've been tracking this, of course, all of these different cases. And listen, I understand it can get confusing because you had the Northern District have some consolidated cases, and the Southern District had some consolidated cases. Those were all put into the appellate courts in the 7th Circuit U.S. Court of Appeals, and then you had preliminary requests to go to the U.S. Supreme Court, so it can get convoluted and a little confusing, no question about it. But all of that was on preliminary requests for temporary relief while the case is dealt with on the merits. And I had somebody on a comment on YouTube ask, well, what does that mean? What do the merits mean? Well, that means you're getting to the meat of the arguments, instead of the preliminary stuff, which was, this needs to be stopped now before we actually get to the meat, because people are being harmed now. All right, so apparently courts, at least after the Southern District did grant a preliminary injunction against the state law, other courts said, no, there's no immediate danger to people. They're not being irreparably harmed. Their rights are not being destroyed at the moment, and the state has a likelihood of succeeding on the merits. That's what the 7th Circuit U.S. Court of Appeals essentially said. And again, those were on the preliminary requests to halt a law while the case is dealt with on the merits. So now we've got in the Southern District the case being dealt with on the merits, and Judge Stephen McGlynn denying a motion to stay proceedings, meaning denying a motion to hold off on getting to the merits because plaintiffs groups wanted to go back to the U.S. Supreme Court to try to have them intervene again. McGlynn said no, they're moving forward. The mandate has been issued, and even yesterday, you have the court in the Southern District, a docket entry saying costs taxed by clerk in the amount of $2,020 against plaintiffs Caleb Barnett, Dane Harrell, Jeremy Langley, federal firearms licensees of Illinois, in favor of defendant Brendan Kelly, Kwame Raoul, and Governor J.B. Pritzker. So that was entered yesterday in the Southern District. And I'm thinking, and again, I'm not an attorney, I'm just an observer, I'm a journalist looking at these things regularly, but I'm pretty sure that's because, they ultimately went to the appellate court, and the appellate courts decided against the plaintiffs. So you got that decision, and there's court costs and such. So that was entered yesterday, but a few days before that, you had Judge McGlynn order a scheduling conference, and this is after you had the scheduling conference from last week, where the judge, again, denied holding off getting to the merits. So McGlynn ordering that there will be a scheduling conference on February 2nd at 1:30. All right, so February 2nd at 1:30. What is that, Groundhog Day? It says the parties should be prepared to discuss scheduling issues and the timeline for discovery. So we're getting to the meat and potatoes of the case in the Southern District of Illinois when it comes to the state's gun and magazine ban. And again, that's coming up February 2nd. But today, at some point, the state is expected to respond to MAG's Fifth Amendment challenge to the state's gun and magazine ban and registry. Now, that's not the only argument. You've got the Second Amendment, the 14th Amendment, and the Fifth Amendment, but they're going to start tackling the issues on all grounds, from my understanding, in a trial that Judge McGlynn's going to hold after they get the list of witnesses they want, the list of experts they want, the depositions done, and then they may be calling people to testify in Congress or to testify in the court and move forward with the hearings and get to some kind of final judgment on that claim out of the Southern District of Illinois Federal Court. So that's where we're at there. But of course, you've got other court action at the U.S. Supreme Court this week. You had the Chevron case being relitigated, so to speak. And this dealt with administrative rules on a federal level. But keep in mind, you've got administrative rules even here on a state level. That was pretty dominant news this week when it comes to gun litigation. But the Chevron case, it's interesting. It really gets into the weeds and whatnot. But here's just a little sample that C-SPAN pulled together of some of the back and forth between the litigants and the justices, overviewing some of the major arguments.
Do judges really rely on Chevron? You want to speak to that?
No, I'd love to speak to that because I think that's an important consideration. I mean, one of the premises of one of Justice Kagan's questions in the first argument was that, you rarely get to Chevron step 2, but there are statistics on this. There is the most exhaustive survey of over 1,000 cases by Barnett and Walker. We cited on page 33 of the blue brief. It found that courts were reaching step 2 in 70% of the cases. 70% of the cases. The Cato Institute brief, you might think, well, things have gotten better because that was a longitudinal study over a number of years. You might think, well, things are getting a lot better because we've signaled that Chevron is on sort of life support. But the Cato ran the numbers for like 2020 and 2021, and it's down to 60%. But it's still well over half the time your average judge in the Court of Appeals is getting to step 2. And Judge Kethledge, he hasn't updated that speech, but as far as I know, Judge Kethledge still hasn't gotten to step 2 once. And that's an unsettlement in the law. That's a disconnect in the law that is very hard to get your fingers around. Like, at least if one circuit says the statute means X and another circuit says Y, everybody can see that. Cert can be granted. This court can resolve the case. But if courts are deciding some cases step 1, some cases step 2 in ways that are radically different, I don't even know how you really unearth that. So I think that's another huge problem with this.
So again, this is about how courts interpret rules, really. The idea is that if the Chevron decision, which allowed for administrative rules, from my understanding, to essentially be the law of the land, you had those saying if that's overturned, then you could turn courts into super legislators, and this idea that courts could then step in and possibly, take away the idea of rules being, crafted by an executive agency to interpret the laws, and then you got a court coming in and reversing that. Then the courts essentially are acting as super legislators, the argument is. But obviously, we've got equal branches of government. The legislative branch crafts the laws, the executive branch executes the laws, and the judicial branch, they interpret the laws. But clearly this is something that I think is going to be decided sometime in June, and it'll be interesting to see how it impacts not just federal rulemaking, but also state rulemaking, for that matter. Here's a little bit more from the oral arguments heard in front of the U.S. Supreme Court as collected by C-SPAN earlier this week.
Were they wrong then? And if they weren't wrong, then what, if anything, has changed since then?
So, Justice Alito, I think they were partially right then. So let me say what's changed and what hasn't changed, i.e. what the court missed back in Chevron. What has changed is we've come a long way in statutory interpretation. And, if Chevron was a response to some of the excesses of the D.C. Circuit in the freewheeling days of the late 70s and the use of legislative history, and, oh, by the way, the text of this statute appears in the margin of my opinion, and I'm not going to talk about it again because I'm off to the races. We now, I think, are all textualists. The focus is much greater on the text of the statute. And once you recognize that, you recognize the problem with deferring at a certain point to the agencies. And let's look at the track record of the agencies agencies before this court. If they are so expert, they should be able to persuade you in case after case that they're getting these statutes right. By my count and by the Cato Institute in their amicus brief, since the court last cited Chevron, the administration is batting about 300 in these cases. So expertise is not all what it's cracked up to be. And that's true even in the most complicated cases. Look at the American Hospital Association's case. I don't think you're going to find a statute that's more complicated than that one. But yet this court had no trouble unanimously saying that you can't have hospital chain-specific pricing without first doing a survey.
Well, I don't know whether you can say we had no trouble.
I was going to say that, but yeah.
So was I.
So clearly, a lot of legalese and a lot of reference to other cases, but the crux is really, can courts come in and interpret rules based off of laws, administrative rules based off of laws? And the reason I bring up the Chevron case, because again, that deals with federal stuff, it still kind of overlays onto what Illinois is dealing with when it comes to the state's gun and magazine ban. Yeah, the legislature passed the law, the governor executes it, the agency makes rules, those rules have a lot of questions, and then the courts are now being tasked with determining whether or not the law violates the Constitution. And the rules in Illinois, what's fascinating is the gun control rules allow for state police to modify the list of banned guns every October 1st. So later on this year, state police are going to be modifying the rules to update the list of banned firearms. So, again, the question and the arguments about the Second Amendment and the clause of shall not be infringed. Well, if you've got an executive agency that could, shift hands at a future election, maybe it goes to a Republican and they just completely swipe out the rules. So the administrative rules and how they're implemented, a fascinating conversation. It really gets into the weeds of things and it's super wonky, but I think it's important that people who are tuned into this do kind of keep an open ear as to what's happening. But obviously, gun control and the rules that follow and how they're implemented and the lawsuits that happen, there's always a pretext to leading to gun control efforts. And we've seen mass shootings across the country, absolutely tragic events where a lunatic with a firearm goes and shoots and kills people and maims and injures others. Just horribly tragic. Nobody wants to hear these headlines and nobody wants to see that happen. But what you do have is people using those events as a pretext to bring about more gun control. But they don't necessarily do that after a thorough review of what may have happened at a shooting, a mass shooting. They don't necessarily look at the motive that somebody may have had when they go into conduct a mass shooting. They don't look at that person's mental health or the police response. The gun control advocates seem to go right to the firearm and want to ban the firearm. Well, after the Uvalde shooting that happened May 24th of 2022, here we are now, January 19th of 2024. You've got the Department of Justice releasing their report, and it's pretty damning. Devastating report for a devastating event, the USA Today network reports. DOJ cops failed in Uvalde shooting. Put the blame on the school's police chief, put the blame on other officers, a 500-page report. Here is the Attorney General, Merrick Garland, giving just an overview of the report.
As I told families and survivors last night, the department's review concluded that a series of major failures in leadership, in tactics, in communications, in training, and in preparedness were made by law enforcement leaders and others responding to the mass shooting at Robb Elementary. As a result, 33 students and 3 of their teachers, many of whom have been shot, were trapped in a room with an active shooter for over an hour as law enforcement officials remained outside. I also told the families and survivors how deeply sorry I am for the losses they suffered that day and for the losses they have suffered every day since. I told them that the priority for the Justice Department in preparing this report has been to honor the memories of those who were taken from them. And I told the families gathered last night what I hope is clear among the hundreds of pages and thousands of details in this report. Their loved ones deserve better.
So obviously you can go read that report yourself, but there are a lot of things in there highlighting the failures of local law enforcement in that case. And we've seen this time and again as well, where even in Illinois, a couple of mass shootings of recent memory, the Highland Park shooting, the suspect in that case who still faces trial after saying that he's going to defend himself, and then now he's back to getting his own attorney. He allegedly got a FOID card despite having Illinois State Police in receipt of a clear and present danger report. You know, we have this thing in Illinois called the Firearm Owner's Identification Card, and it's required for anybody who wants to purchase or own firearms or ammunition to register with Illinois State Police that they are a firearm owner, and they get an ID card. And then they have to present that ID card to state gun shops and so forth. Illinois is one of, I think, 4 states that have this thing. Obviously, it's being challenged in the federal courts with some movement that's expected to happen in May this year. Another case by Attorney Thomas Magg down in the Southern District, so we'll watch that. But regardless, the FOID card is there to prevent people from getting a firearm that aren't supposed to have one. Say they have a criminal history, a violent criminal history. Say they have a history of being in a mental health institution. Say they have other prohibiting factors, like having clear and present danger reports issued against them. And that's what exactly was the case with the Highland Park shooting suspect, with state police acknowledging they were in receipt of a Highland Park police clear and present danger report before that suspect filed to get a FOID card and was granted a FOID card. State police say that they've fixed that in the rules. But you also have, even before that, in 2019, the Aurora warehouse shooting that happened. That was an individual who had a FOID card despite having a criminal history in another state, but when he went to apply for a concealed carry permit, that's when Illinois State Police found the prohibiting factor and then canceled his FOID card, and they were supposed to go and revoke the FOID card from the individual, but they never did that. So after the FOID card revoked, a certain amount of time goes by, this individual takes a firearm to his employer and shoots and kills people. So clearly, these are other instances where law enforcement has dropped the ball, so to speak. And listen, it's not an easy job, law enforcement. There's no question. But you got to think about all of these different things that are put into place to prohibit or to help, and then things aren't completely followed through. And should there be some kind of negligence leveled against people? And again, what this is just a conversation of people's swift reaction, knee-jerk reaction, some may say, to ban guns after a mass shooting, instead of looking at the loopholes and the problems and the mental health and so on. So there's obviously a lot more to be said about all of this. So clearly, we'll be tracking this as we progress throughout, but it's a tough subject to handle, and I appreciate you guys being part of the conversation each and every morning, checking in live with Bishop on Air. Be sure to hit like, subscribe, notification bell, all that jazz. Be sure to also check out the merchandise shop if you want to support the program, and we'll be back with so much more each and every weekday morning. It is Bishop on Air.